Um, should we get started? We have loads of participants. Okay, I'll introduce you. I think we have lots of people who've joined. Thanks for joining our virtual biodiversity coffee. So Annie is here today to present on the legal challenges and possibility for future nature-based solutions based on a case study on REDD+. And Annie's doing her, well, I think you've all heard, we've been talking about it before, but doing her MPhil here and looking to start a PhD in October around this subject. So thanks, Annie.
Great. Thank you, Cecile, for the introduction. And thank you, everyone, for being here. If you didn't hear our little conversation at the start of this presentation, this is kind of the seminal research, or my first exploratory research into the legality around nature-based solutions and the legal precedent that has or has not yet been established. So I'm excited to share with you and get your feedback. And I think, as a lot of you know, there has been a growing popularity around nature-based solutions. We're seeing it as a catchphrase in the news from the UN Environment Program. You know, just a couple days ago, the UK announced its green economic recovery with nature-based solutions written into this. We're hearing a lot about tree planting, etc. So it's gaining all of this global popularity. In this, we see the UN declared their decade on ecosystem restoration for this upcoming decade. And this really centers around nature-based solutions and integrating human well-being with biodiversity restoration. And finally, we come to the IUCN, who's kind of the figurehead organization establishing law around nature-based solutions. They had their World Conservation Congress, which was planned for 2020 in Marseille for the summer. It's now been postponed, but at this World Conservation Congress, or WCC, as I'll refer to it, they were meant to actually formalize their definition of nature-based solutions, or NBS, that they've been developing a lot of research on and developing some law around. So we'll see what comes out of that in 2021. And just as a brief introduction to the IUCN, they're kind of an interesting lawmaking body because they're not explicitly lawmaking. They don't come up with treaties. They don't have signatories, but they are a group of governments and private organizations and NGOs, and they provide these reports and guidelines that come out of their World Conservation Congresses in the form of resolutions and recommendations out of each WCC that actually guide international law and can be considered international soft law, so it's unenforceable. However, it does have a real impact in kind of shifting the narratives. So we are going to be considering the IUCN's resolutions and recommendations as the law that has been established around NBS. So what came out of the IUCN in their 2016 WCC was Resolution 69, entitled Defining Nature-Based Solutions. And they define them as such: actions to protect, sustainably manage, and restore natural or modified ecosystems that address societal challenges effectively and adaptively, simultaneously providing human well-being and biodiversity benefits. So this is the definition of nature-based solutions that is legally established internationally. And what I was tasked with this paper was writing about the issues that international lawmakers will face when drafting laws around nature-based solutions going forward. And I found that actually emerging from this legal definition from the IUCN were kind of three issues that make it difficult to address nature-based solutions in law. Those being, one, in the definition, it focuses on ecosystems. Ecosystems are inherently made up of the context. They're context dependent. They are place-based. When governing NBS, you're going to have to look at the specific ecosystem. No one NBS is going to work across all different ecosystems. Secondly, we have adaptively here. You're looking at ecosystems as constantly evolving. They are adaptive by nature. And then third, we have the human well-being and biodiversity benefits. Now, this makes nature-based solutions law really unique in the international law sphere, because with a lot of international environmental laws that exist, they actually separate human well-being and biodiversity. And here you're seeing with nature-based solutions, you're putting them together. So it's this whole new, essentially, open canvas for what this integrated law can look like. But when you have humans in the environment, what comes into play are different indigenous and local community land rights, land tenure rights. And so we're going to explore a couple of those. So just as an outline, I'm first going to start with context around, what is the legal development of nature-based solutions? What exists out there? It's little, but there is some law that we can work with that's established precedent. Then I'll go into just a brief explanation of REDD+ as a legal nature-based solutions case and how I'm using it in this paper. Then I'll go into those legal challenges in developing international law around nature-based solutions. So the first one I'll analyze is how nature-based solutions have unknown futures. The second one is that the nature-based solutions are place-based. And the third is that nature-based solutions integrate humans in the environment. So I'm going to be looking at these challenges that emerge from the very definition and looking at the legal issues that are there. And while the paper focused primarily on the issues, I wanted, for the purpose of this presentation today, to look and spend some time on overcoming the challenges. What can we do? What are the next steps on the international environmental legal sphere? So first, with the legal development of nature-based solutions, a lot of what is cited in the IUCN's documents that came out of their Hawaii 2016 WCC all referenced back to the Convention on Biological Diversity, the CBD, specifically their ecosystem approach, which looked at ecosystems, centering ecosystems for biological diversity, and even more specifically, the 12 Malawi principles to the ecosystem approach, which look at operationalizing the Convention on Biological Diversity. So how can, what does it look like put into action? And what does good ecosystem management look like? And so the IUCN, when building their definition of nature-based solutions, they used those legal documents. And of course, as I've mentioned previously, it came out with, the IUCN came out with Resolution 69, which has the definition, and then it also has 7 preliminary principles which guide nature-based solutions. So you have a bit more content to work with on the legal front. And then also coming out of that same World Conservation Congress was Recommendation 107, which looked at operationalizing the definition of NBS. So how to apply it to different nations. So again, here's their definition that came out of that and really what we have to work with. So now we'll look at REDD+ as a legal NBS case. I'm sure a lot of you are much more familiar with REDD+ as it stands and its nuances. It's a very complicated, developed piece of environmental legislation. But for the purpose of this presentation, we're just kind of taking it at face value. But to get those of you up to speed who aren't familiar, REDD+ stands for Reducing Emissions from Deforestation, Forest Degradation, Conserving and Sustainably Managing Forests, Enhancing Carbon Stocks in Developing Countries. And this multi-scalar, multinational program was spearheaded by the UNFCCC. It came out of their Conference of the Party, the 13th Conference of the Parties in 2007. And in short, now it's been developed a bit further. It provides financial incentives for developing countries to reforest or protect the forests that they have. And it's considered, legally considered as a nature-based solution by the IUCN. It appears cited in their World Conservation Congress documents. But coming out of Lister, McKenzie, and McDermott's book on laws and REDD+, and reducing carbon emissions, they talk about 3 challenges that emerge out of REDD+. First, REDD+, as it's this really, really big legal framework, it needs to govern across scales. So it's an international law that really needs to be effective at the national level and the local level. Second, there's a lot of contention around the rights of Indigenous people and local communities that live and are dependent upon these forests. And the rights are infringed upon in certain contexts, and I'll go into that a bit more. And the third challenge that they cite is that the differing size and length of all of these different decentralized projects that are proposed at the international level, the differing size and length, ends in different outcomes. And these 3 challenges are also quite aligned with the 3 issues coming out of NBS law. And so that's why I chose REDD+ as a case study for this. So to get into the first issue about how nature-based solutions have unknown futures, in preliminary principle number 5, coming out of that resolution 69, it talks about how nature-based solutions maintain the ability of ecosystems to evolve over time. And so in essence, written into NBS law and definition is that ecosystems are ever changing. And what this does is it leads to these conditions of deep uncertainty and making sure that lawmakers are having to make legal decisions under conditions of deep uncertainty. And that's constituted by uncertainty around the context, the functioning, and the outcomes of the project. So, as you all are very well versed in ecosystems and you're all biodiversity practitioners or academics, you can understand that as ecosystems have their agency, there can be nothing that's fully predicted and certain about what's going to happen from an NBS project. There is uncertainty around that. Now, law is not really meant to handle or designed to handle surprises as it's written into the Malawi principles. It says that managers need to handle surprises. Well, law isn't necessarily adaptable to that. So it's all about this challenge of writing adaptable law. And in REDD+, there are these safeguards written in to ensure the rights of humans and ecosystems and environments are taken care of under international law. And in the safeguards, some kind of qualifier words were added at COP17, talking about, where appropriate, protect the rights and flexibility and allowing for improvements. So you can see that in these REDD safeguards, they were attempting to make this law adaptable to different contexts, but to changing contexts. But at the same time, that provides an issue because then it actually weakens the law as it stands. So that's this challenge around NBS having unknown futures. Now the second issue right here is that coming out of the definition is that NBS are place-based. Now in preliminary principle 3, it says that nature-based solutions are determined by site-specific, natural, and cultural contexts. So it's really referring to, no two NBS are going to be the same in different contexts. And you think about the research coming out on tree planting and how heterocultured forests are so necessary when thinking about carbon sequestration, because monocultured forests are going to be so detrimental. So you're thinking about matching that forest that perhaps was there or is still there, and making sure that when you're reforesting, you're making sure that it's place specific. Now that makes it difficult for a law that's coming from an international global scale to come down to that local or down to that national scale and determine what NBS is going to work in what place. So you're looking at law that needs to govern effectively across scales. Now, Malawi Principle 2, which feeds into the IUCN's definition of NBS, talks about how decentralization of ecosystem management is so necessary. But then the issue that comes up with that is that you're also decentralizing responsibility. So can that enforceability be global, or does it need to come, where does it come from? So it's integrating those scales, it's a big difficulty. Now, we actually see this place-based issue coming out of REDD+ with community forestry, because REDD+ really wanted to integrate participation of local stakeholders in order to make sure that the NBS was designed specifically for that place, with that knowledge informing it. But then some issues came out of the community forestry, because the financial incentives were, or the financial incentivization was going to the national government, and some nations were actually using the locals as labor. And so that ended up being highly criticized and contentious, but even that, the rights of the people that lived in and around the forests and were perhaps doing this labor in a REDD project, that was dependent upon their legal standing in the nation. So that brings us really smoothly into the third issue around developing new laws for NBS, which is that NBS integrate humans in the environment, addressing those human well-being and biodiversity benefits at the same time. Now, again, as I mentioned, this is kind of a blank legal canvas. A lot of times, laws have looked at, nature as solely a resource, and kind of kept humans separate from it. So this is a place in which laws can be well developed. And looking at preliminary principles 3 and 4 out of Resolution 69 on defining nature-based solutions, they talk about integrating the knowledge, indigenous knowledge, and participation of all stakeholders, especially local stakeholders, around the area where an NBS will be planned. So from its very definition, NBS is wanting to integrate all of these knowledges. If you think about this from an international legal perspective, though, that's going to be very time consuming. However, a lot of scholars are going to argue that it is worth it to make sure that this knowledge is taken into consideration. And second, you don't want to exploit the knowledge, use it, and in the case of REDD+, have the countries then benefit with local and indigenous community rights being taken away. So there's actually been a lot of REDD+ resistance from indigenous rights groups, because depending on which country the REDD project is in, the legal standing of indigenous peoples is going to be different. And so some countries, REDD+ will uplift these knowledges and participation, while in others it will actually reduce the rights and really centralize the forestry to be completely state governed. So it's these different frameworks, but you can think about the difference between REDD+ was that it didn't integrate these indigenous and community rights into law until COP 16 and 17, versus nature-based solutions, its law is very new, and it's actually, even if it's stemming from the Malawi principles, indigenous knowledges, participation, community rights, those were all established from the Malawi principles and in the very seminal Resolution 69 defining NBS. So I think there is a distinct difference between NBS at large and REDD Plus as a case study there, because the Indigenous rights are written into the law. But how do we operationalize those and make sure that that's functions across scales? So that's what we'll go into in this section around overcoming the challenges. So I've just laid out for you perhaps a canvas that looks a bit dire, very complicated in my mind, and you know, just with a lot of issues. But I think it would not be doing it a service unless we talked about the next steps and what can the World Conservation Congress of the IUCN in 2021 do to, you know, further develop the legal development of nature-based solutions. So first, looking at tackling the challenges in the unknown futures. You know, so I talked about adaptive law and how do we write adaptive law. Well, I turn here to McDonald, who's written about adaptive law and laws for adaptation quite at length. And she talks about 3 steps into writing adaptive law. The first is looking at adaptation assessments of the site. So you go to the site where the NBS is meant to be governed, and you want to do this kind of preemptive adaptation assessment of it. Second, needs to be a coordination between different levels of government. So it's, again, referring back to that, the different scales of governance, and making sure that there's coordination, there's communication between the international, the national, the regional, the local. And finally, she talks about for adaptive law, you need to improve public participation. So again, that's kind of integrating all 3 of the issues into 3 solutions, so including participation. And that's the 3 of those together are going to form or inform a law that can be adaptive to different contexts, to changing futures. Now, this takes time, naturally, but as McDonald argues, it is worth it because you're going to have a law that's long-lasting, that's sustainable. Now, to overcome the challenges of the place-based nature of nature-based solutions, you really want to strengthen the language in the international legislation. So right now I talked about how in the REDD Plus safeguards, there's, you know, the words of where appropriate or flexibility. In the IUCN's recommendation 107, they talk about you know, all of these operationalizing of NBS are an invitation to the states to bring this law into being. So it's these kind of weakening language that makes the law more adaptable to different places, but at the same time means that different places, it's not going to scale up the NBS as much as we want it to. So how can we balance, we need to work on balancing that legal language to balance the adaptability to states and the power of the international law to scale up the nature-based solutions. And then finally, when looking at overcoming the challenges around NBS integrating humans in the environment, we want to make sure that rights of Indigenous peoples and local communities are you know, solid at the national level, because the national level is really where these are going to be determined and will determine whether REDD Plus or any other NBS will enhance the rights, participation, knowledges of the people there on the ground at the local level, or if it's going to take those away. So you're looking at legal standing and access to decision-making of these people. And the way to do that is to ensure that the Indigenous peoples and local communities have a stake in the project and are participating. So that could take the form of participation at the international lawmaking level so that it trickles down to their countries and they can bring it back to their countries. And it's all about that access. So, I mean, in conclusion, these are no simple answers to no simple challenges. But as nature-based solutions are gaining popularity, as we're hearing more about them across the news, across the different NGOs across different lawmaking bodies, it's really necessary that we start to establish more legal precedent around them in order to scale them up, as we know that they do provide that human well-being and the biodiversity benefits that the world so greatly needs. Thank you.
Thank you. Thanks, Annie. Yeah, thanks. That was amazing to frame all this in the legal context. There's just a lot to take in.
Yeah.
I'm wondering if anyone would have any questions.
Yeah, Vinda, I'll just ask a question. That was very interesting. Thank you. It was very interesting to get that perspective. I'm wondering how many of those challenges you highlight are more general challenges, a lot of law, whether it's around development or economic law. Also, if it is in the context of unknown futures, and can be place-based or country-based in specific contexts. And how many of these features are particular to nature-based solutions as a unique challenge, or are they just a general challenge that most international legal frameworks have when actually being deployed?
Yeah, no, I agree. I think so. International laws, yeah, it's its own its own beast, so to speak, and a lot of it, especially centering around the soft law in general, full stop, those are the general challenges, because a lot of international law is this unenforceable soft law, these guidelines for nations to take back to their own places, so to speak, and integrate. So I would say I agree with you, especially the first two, the unknown futures and the context-dependent nature of nature-based solutions could be applied to other ones. I think the integrating humans in the environment is new, at least on the international environmental law front. You mentioned development law. It comes up in that a bit. But I think as these three unknown futures, place-based and integrate humans in the environment, as they emerge specifically from the definition, I think they require some specific attention to NBS law. But I agree that they are broad in general. I think the unknown futures bit too, in terms of ecosystems always changing, I think is applied to that specifically. That's a more particular issue to nature-based solutions, as ecosystems change and develop. And I think in nature-based solutions specifically, there is this knowing of indeterminacy, right? You need to know that perhaps you will not know what comes out of it. And I think that could be more specific to nature-based solutions.
Thank you.
Thanks. Are there any other questions? Anyway, I was wondering what the next steps are then, how you're going to take this forward for your PhD.
Yeah.
Yeah. Yeah,
definitely. So my PhD, for context for others, is going to be around sort of the NBS infrastructures that involve animals. And I think it was so necessary to do this research in order to inform just the baseline of my PhD of what I'm working with, because I'm really passionate about doing applied research and making sure that what I learn is going to be communicated, as Carlin and I talked about earlier, and operationalized. So I think knowing the legal framework before I enter into an investigation around nature-based solutions infrastructures is really important. So I'll apply it that way. Also, I come from a rhetoric background, looking at the sort of communication that's inherent within laws, and that will be integrated into my PhD as well. So not only the international laws, but how do these affect nature-based solutions on the ground, but also how do they affect attitudes, behaviors, perceptions of nature-based solutions as, say, communication artifacts. So that's kind of how this also will feed in to my PhD.
Great, sounds really good. Are there any other questions?
Hi, I have one.
Mm-hmm.
Yeah.
Sorry, I really liked the presentation, thanks. I was just wondering, how applicable do you think adaptive law is to developing countries where there can be a lot of bureaucracy and where perhaps more rigid targets are more necessary to get things done?
Yeah. I mean, I think the adaptive law as applied to this context is, it doesn't do away with the rigidity in the setting of those goals and the meeting of objectives. I think that it could act in those contexts as a secondary, not a secondary law, but a parallel law that could really help with the adaptability of the nature-based solution itself and the adaptability of the context, while also working alongside, perhaps, and this is just me thinking, but working alongside a law that has, I guess, stricter objectives. The only issue is that as those objectives, there has to be an understanding that those objectives are projections and can't necessarily be 100% known. So, I mean, you bring up a really good point. That is one of the issues of this international law, is that law functions in a rigid, objective, goal-oriented way, and the adaptive law may not work everywhere, but could work alongside traditional law.
Right. Okay, thank you.
Yeah, of course.
Any more questions? Okay, I think we have covered questions. It's been super interesting. Thanks, Annie. It was really, really good to get your perspective on this, and I'm sure you'll get more people contacting you through this. We'll make the film available to the network, and we'll have it on the website and your contact details with it, so you can then be accessible. We've got so next week we have a session run by Conservation Optimism, and Caroline, would you like to introduce it?
Sure. And so we teamed up with Conservation Optimism and Rebecca and Caroline from the Climate Psychology Alliance, and they're going to be running an hour-long session on climate grief and eco-anxiety, specifically for conservationists and people who work within this sector. And after that session, if you would like to stay on, they'll be doing 2 breakout rooms, much smaller breakout rooms, just for people to have conversations and chat. It actually sounds really interesting. And there is more information on the network website and also on Bookwend. So please do sign up. If you have any other questions, just ping me a message, and I'll get back to you.
Thanks. So I hope you'll join us then. And thanks again, Annie. It's been really, really good. And just contact us to let us know if there's anything we can do to help put you in touch with anyone or promote your work. And
yeah, always great. Any help helps. But thank you for having me. I really appreciate it.
And if anybody else would like to take one of these sessions like Annie's just done, please do get in contact with Cecile or myself at the Biodiversity Network email address. So thanks very much, everybody.
Exactly. Thank you.
Thank you.
Are we leaving and coming back?
Let's do that.
Okay.